Hey everybody. Today we have a very special guest, a old and one of my closest friends, David LaVine. He is not only a great person, but an expert attorney. He's the managing founding partner of Sanchez Fisher Levine LLP. They focus on litigation for entrepreneur-led businesses and large corporations. So, David, welcome to the show.
Appreciate it, Jeff. Really happy to be here and really happy that we've been able to cultivate our friendship over the years and do business together as well.
Yeah, awesome. So let's dive into it. I think let's just start with general background on your experience with litigation, and how you came to found SFL.
Sure. So my name is David LaVine. I am one of the founding partners of Sanchez Fisher Levine. We are a complex commercial litigation law firm. We have about 15 lawyers. We're primarily based out of Miami. I head the Miami office of the firm. We're right on Brickell Avenue. But we also have a Fort Lauderdale office and two satellite offices, one in Los Angeles and another in New York. And it really runs the gamut as far as the types of business disputes that we handle. We handle everything from breach of contract cases to fraud and really everything in between. I've been practicing law for about 14 years now. Sanchez Fisher Levine, we created just over 5 years ago. And before that, I worked at a prominent litigation firm in South Florida where I was a partner there. And before that, I went to law school at FIU and undergrad at Florida State University.
Awesome. So let's dive into some useful tips for entrepreneurs. You talk about your experience working with entrepreneurs for both small and medium-sized businesses, and the things that you see as common themes with entrepreneurs, and things that they should know when it comes to entering contracts, or just how legal representation can help them.
Sure. So we have a lot of experience with small and medium-sized companies, and I would say our role in the process really fits into three buckets. In the broadest sense, we serve as outside general counsel to companies where a company may not want to hire a lawyer full time, put them on staff as in house counsel. And so they like to have the option of having a lawyer at their disposal on retainer to deal with any day to day issues that may arise, or the drafting of legal documents such as NDAs or licensing agreements, vendor contracts, and also to update and refresh legal documents. And so we serve in that role as that outside general counsel. In addition to that, I would say the second bucket is internally, representing one side of a company against the other side of the company that they may be claiming is doing some sort of wrongdoing. And so in that context, we'll handle partnership disputes where one partner is accusing the other partner of wrongdoing, or shareholder disputes, typically associated with breaching an operating agreement or breaching fiduciary duties such as operating with good faith or with a duty of care or loyalty, or usurping corporate opportunities, things like that. And then the last bucket, I would say we externally represent companies when the company as a whole is involved in a legal dispute with some third party. Oftentimes that's associated with a third party breaching a contract. It could also be intellectual property related with trademark infringement, or somebody violating a confidentiality agreement and potentially also utilizing improperly the company's trade secrets. And so typically we represent companies externally against other parties in business disputes as well.
Yeah. So it seems like just a general blanket statement would be anytime things don't go to plan and companies either want to remedy those situations, or they need to protect themselves against someone who's searching for remedies for things not going to plan. Everyone hopes that when they enter in a contract that it's all going to be sunshine and roses, but we know that's not the case. And so when that happens, you want someone that's on your side, that understands how you can utilize the law to the best of the ability to protect yourselves or to get compensation. Is that right?
Exactly. And that assumes that there's a written contract. Sometimes in a business relationship, there is no written contract, and people are going off of a course of conduct or a verbal agreement. And those oftentimes result in, or can result in, disputes as well. So understanding what protections you may or may not have under the law in those contexts where there may not necessarily be a written agreement governing your relationship is also very important in understanding what options business people have available to them under the law.
Yeah, that makes a lot of sense. So on that note, what are what are the key legal protections you think that entrepreneurs should think about when entering into contracts? What are the things that they should think about to protect against the risk of litigation?
Well, first and foremost, I would always recommend that people consult with a lawyer and hire a lawyer to help them through the legal process and help them navigate through the creation of contracts and arrangements, either internally or externally with other business people. Because oftentimes we come into situations with small and medium sized companies where they're doing things on the cheap and entering into arrangements and dealings. And they think that they're entering into a contract that says a certain thing, when in reality, the contract may not be saying that. And so when a dispute then arises, they have been operating under a set of circumstances, the entire business relationship that may not exist. So it's really important on the front end to have the contracting party know what they're actually entering into. As far as considerations that they should be looking at, they should obviously want to protect whatever they're expecting out of the relationship as much as possible. But as you mentioned, as great and well intended as a relationship may be going into it, that may not be how things actually play out. And while people may be really lovey dovey on the front end, 2 years into a relationship, something may have soured, and then they're in a dispute with the other side to that transaction. And so, while it may be tough because when you're entering into an agreement, when you're a business person, you're trying to make money. And so you're trying to get this done pretty quickly and you're on great terms potentially with the other side. You really want to go into an agreement looking at the worst case scenario. What happens if this doesn't go as planned? What are the types of different scenarios that may play out where we would not be happy with the arrangement? And then taking it a step further, what do we want to govern our relationships in the event that this dispute or this relationship sours?
Yeah.
So what do I mean by that? So for example, you have options available in an agreement. If a dispute arises, do you want to go to a court of law or do you want to go to arbitration? There's pros and cons of both. Do you want to go right into litigation or do you want to have a pre-suit requirement and potentially a notice provision where you or the other side is given an option to cure the alleged violation of the agreement? Sometimes people like that. They like the ability to know if the other side's unhappy with their performance of that and have the ability to potentially rectify or cure that before any litigation ensues. Other times, parties don't like that because that may hinder their ability to go to court quickly because they have to comply with a 30-day or 60-day or sometimes longer pre-suit requirement. Same things with the types of litigation. Do you want to be able to go right to a court of law and not have to pay for a judge by the hour? Or do you want to go to an arbitration where you have to pay the arbitrator by the hour and you have to pay a tribunal? And there's pros and cons with both. And so we don't know the answer going into that relationship on the front end, but these are the conversations that we have with our clients so that they hopefully, while they may not know the answer at the time, they're thinking about it and seeing the potential issues that can arise is important for their ultimate decision making and deciding ultimately whether to enter into a contract, and if so, what should be in that contract, or at least going into the relationship with eyes wide open.
Totally makes sense. And so that's going into the contract, making sure that they get the contract set up right to have the right protections in place and the right plan should something go south. Walk me through a scenario where you've been working with a client, we can keep it confidential, where things had gone south and you help them navigate a difficult situation. What's an example where you can show or you can explain how you've navigated it that might be a little different than a typical attorney relationship?
Sure. So we had a case recently where we represented a foreign client who had entered into a business dealing with a U.S. entity, had signed an agreement, though the foreign client was very unfamiliar with the United States legal system. But our client had an event coming up on a time sensitive matter and got into a business dispute over an agreement that candidly could have been drafted a little bit more clearly. And so our client needed some certainty with respect to this event that was coming up, had time constraints associated with it, and you can't force somebody to do something unless you go to court and get some judge or arbitrator to issue a ruling that hopefully goes the way you want it to go.
Mm.
And so knowing that there was this event coming up, knowing that our client needed some certainty, and then reading the agreement, we saw that there was some roadblocks to be able to get our client the relief that it was seeking. For example, there was an arbitration provision in the agreement that required a 3 arbitrator panel to make any decisions, which means that there were 3 people that had to be appointed by an arbitration tribunal to decide the dispute. And that's very, very costly, because not only are you paying for 1 arbitrator, and those rates can range $400, $500, $600 an hour or more, but now you're tripling that fee. But also that takes time. It takes time to appoint a 3-member arbitration panel to decide a dispute with the other side. And so we had to account for that roadblock. And so we were able to navigate the rules of the arbitration tribunal that was in the contract to see that there was an emergency procedure that allowed for the appointment of an emergency arbitrator to decide pressing issues such as the one that we arguably had. And so we devised a game plan centered around filing an emergency arbitration, given the time-sensitive nature of the event that was coming up. And the difficulty also was, and the challenge was, we were representing a mid-sized company, and even with this plan that we were devising, because it was an emergency, because it required an arbitration tribunal, there was a lot of front-end costs that we had to make our client aware of. And while our client wasn't happy, we always like to weigh the pros and the cons of different courses of action. And so ultimately, we ended up filing an emergency arbitration. We filed a motion seeking the relief that we were seeking on an emergency basis. And that put a lot of pressure on the other side to have to respond, and also pony up money and dealing with the filings that we were making. Mm-hmm. And ultimately, we were able to reach a confidential resolution that ended the litigation, provided our client with certainty moving forward with this event that was coming up. And obviously that, on a business aspect, helped our client tremendously.
Yeah, that's really interesting. So it sounds like to me that you understood both the legal and non-legal considerations around the situation. You were able to manage both of them to get a successful result. That's a lot different than many attorneys, where they only want to focus on the legal side and let the legal play out however it does. And so, yeah, nice job. That's pretty cool.
That's an excellent point. So yes, as counselors, we like to provide our clients with legal advice, which obviously we do all the time. But the reality is we're dealing with clients who are in business. And so they need to be aware, cognizant that whatever happens in the legal sense also impacts the business that they're engaged in. And so over time and with experience, we get better and better in counseling clients to just appreciate the business aspects of it, or to at least let us know how it may impact their business, and maybe what we are looking at on the legal side may not be best for them, and let's see if there's other options available to them. So absolutely, always look at the legal aspect, but consider it in the context of the business that your client is in.
Makes sense. So talking about the constraints when we think about litigation, how do you advise business owners to manage or to approach the balances between wanting the end result, that is getting their remedy, that their goals, achieving their goals, with the financial constraints and time that it'll take to get those? How do you typically approach that conversation with clients that only want the right answer when there might be a bunch of different options in front of them?
It's not easy, and we pride ourselves on managing our clients' expectations, not just telling a client what we think they want to hear, but telling them what we think they need to hear. And it may not always be what they want to hear. And so in managing their expectations, what we can do and strive to do is present a menu of options available to our client. You can do option A, but option A will cost you X amount of dollars. You can do option B, which will be slightly cheaper than option A, but may decrease your likelihood of getting the best case scenario that you want. As lawyers, we cannot guarantee a result. What we can do is provide different options for clients to consider, provide budgets on our experience on how much those options will cost, provide counseling as far as pros and cons of different options. But ultimately, once we present this menu of options to a client, it's ultimately up to the client to decide what works best for them, given a whole host of variables. All right, perfect.
All right, cool. Yeah, that makes a lot of sense. And that's a great approach versus a lot of attorneys who only are able to see one path forward. So that's great. Now, talking about entrepreneurs specifically, what are the most common overlooked legal risks that entrepreneurs face, and how do you advise them to approach those?
So, one of the most common legal risks that entrepreneurs may face is that when times are great, when business is booming, when you're making a lot of money, you tend to just ride the wave and see where it ends up. And you may overlook the details of agreements that you're entering into. You may not enter into agreements at all. You may not be crossing every T or dotting every I, and you're just rolling with it.
Mhm.
Sometimes that may work out, but other times it doesn't. And when it doesn't, and then you go back over the contract governing your relationship that potentially is not going as well as it was, and you are realizing that things aren't memorialized as well as it should be, that's when problems start to arise. And so, one thing that we do when we counsel our clients is we like to audit all of their documents. And so, while we may not be the right attorney to do an employment issue, we hopefully identify issues for the client, point it out, and can put our clients in touch with lawyers who specialize in certain things. And so, things for entrepreneurs to consider, some of the main things would be foundational documents. So internally, are all your ducks in a row? Do you have an operating agreement? Does it say what you think it says? Do you have a partnership agreement? Does that say what you think it says? Your employment documents. We work with a lot of great employment lawyers. Do you have employment agreements governing your relationships with your employees? Do you have independent contractor agreements?
Mhm.
Are your employees, or excuse me, are your independent contractors really independent contractors, or should they be classified as employees? Do you have an employee handbook? Things like that you should consider, because those things, while everything may be great right now, it may lead to problems down the road.
Yep.
Intellectual property. Have you registered your trademarks? Do you have any patents that are registered? Are you protecting those intellectual property rights? Are you entering into non-disclosure agreements with potential business partners? Do you have confidentiality agreements with your independent contractors or vendors? Do you include attorney's fees provisions with your customers in the event that services aren't rendered like they should be under agreements? Do you want attorney fees provisions? So these are the types of things that on the front end, we like to discuss with our clients and
Yep.
at least put them in touch with specialty lawyers that may do certain intellectual property like patents or employment services. And that way they're accounting for things now that may not be an issue, but will save them a lot of time and heartache down the road by just
Yep.
having some of their core documents set out on the front end. Because like I said, when times are great, people don't think about those things.
Of course.
When disputes happen, that's when everybody rolls up the curtain or opens up the curtain and takes a look at what's underneath, and sometimes they're not happy with what they find.
Yeah, 100%. That's why it's so important to work with the right advisors when it comes to legal. Same thing we do on accounting side, looking after our clients financially on a regular basis, helping you see around the corners, and then also advising you when we think you're making decisions that may not be in the best interest long term. Same thing from finance to legal. So both are needed, and couldn't agree more. I'd like to go into see if you have an example of a situation where you were working with a client and you turned a litigation or potential litigation to a business opportunity. Do you have anything, any scenarios where that happened?
I don't have a particular situation, but I will say this. My general model for small and middle sized companies and entrepreneurs is that litigation is not a great business model. Some people think, oh, I was wronged, and therefore I need to sue because I got to show everybody that I'm right, and I got to show the person who screwed me that I'm right. And while sometimes it makes sense to file a lawsuit, oftentimes or other times it doesn't make sense because there's a whole host of business practicalities that occur when you get into formal litigation. And so, for example, if you have a relationship where a dispute starts to arise, you may not want to go and jump straight to litigation. You may want to try to resolve that pre-suit to salvage the business relationship.
Say more about that. What are the things that people should think about before they get into litigation? What are the qualitative consequences of litigation that people might not think about when they first think about suing somebody?
So litigation is expensive, and litigation, when you file a lawsuit or get sued in a lawsuit in court, it's generally speaking public. And so your dirty laundry is out there for people to look at. And litigation is time consuming and it's expensive. And so while you may have a great idea that I want to file this lawsuit, you may not be thinking about, well, for the next 2 or 3 years of my life, I'm going to be consumed with this litigation on top of all the day-to-day business functions that I'm also serving in my role as chief operating officer of the company or CEO of the company. And so you'll be sitting for depositions, you'll be producing documents, you'll be dealing with the attorneys on a routine basis. And so those are considerations that should be had on the front end. Other times you haven't really looked at the agreement in a while that you signed that serves the basis of the dispute that you're in, and you may not realize that the litigation is required to be brought in California. You may have a New York company or a Florida company. So now you have to add that cost on top of everything else that you have going on. So those are all types of considerations that businesses should look at. Also, PR. How is this going to look in the public? How is this going to look with competitors? Am I going to be perceived as the problem child in the industry that nobody's going to want to be doing business with me anymore if they know that they're just going to be in a lawsuit with me in the future? On the flip side, we represent companies that know the inherent risks of litigation, understand the costs of litigation, but need to make a statement in their particular field that we will not be taken advantage of and we will enforce our contracts. And so it goes both ways. And just having those considerations is important.
Yeah, and having a legal team that understands the considerations and is willing to work under both of those scenarios is really important. Not just someone that is looking to increase fees and create and generate as much fees as possible, regardless of the outcome. Someone that can really be that strategic advisor.
To that point, one common misconception that we face a lot is if you win the lawsuit, there's this misconception that you automatically will get paid by the other side. But that's not the reality. Your best day in court is you win a final judgment, let's say for $1 million, but you get a piece of paper as your final judgment. That's only half the battle. The next battle is there collectible assets on the other side to be able to actually collect on your judgment? So one consideration needs to be, is the other side collectible, where if I even win, which no attorney can guarantee, but if I win, can I collect? And so when you ask for an example of a potential litigation turned into a positive outcome or a business opportunity, it's knowing when to walk away. When you may be right, you may ultimately win, but I may not get everything I want right now, but I'm willing to walk away. I'm willing to make a business decision to minimize my risk, minimize my exposure, cut the bleeding now, stop the bleeding, and know when to walk away or know when to settle or reach a resolution that's outside of having a final, award in litigation.
Yeah, that makes sense. So, you can get into a situation where you might win, but by pursuing it, it costs you more than if you wouldn't have pursued it at all. And makes total sense. So looking into the future, going to our crystal ball, what are What are some emerging legal challenges that you see facing entrepreneurs in the next 5 to 10 years, and how do you recommend they navigate that?
I think the amount of information accessible to the general public with artificial intelligence and just the internet, the way it's grown to where everybody has access to unlimited amounts of data. And so you're going to continue to see data issues associated with potential data breaches. You're going to have issues with artificial intelligence and how it's being used. And is it used in a way that is in compliance with the law, including antiquated laws that may not be accounting for artificial intelligence or different types of emerging technologies? And so there's going to be a constant issue, I think, there on how these emerging technologies play out in the wake of potentially antiquated laws. So that's on one aspect. The other aspect is knowing what information is useful and what information is not useful. So a few years ago, you had these automated legal services that can draft your contracts or draft your wills, and you may have thought that what you were using to save money was benefiting you because it looked really good when you were creating it. And then several years later, when there's a potential dispute and you go back and look at that and you consult with a lawyer, that may not be anything you thought you were entering into. So just being able to be competent enough to know what you don't know, to say, yes, there's all these emerging technologies out there. I may think I know how to use them, but I may not really know the full extent of what I'm looking at, and knowing when to consult with a professional and when you need to consult with a lawyer is going to be huge moving forward as you continue to have access to so much information.
Yeah, totally agree. It seems like throughout our conversation, it's just been the common theme is you can save a lot of money up front by doing things the wrong way, and it can cost you a lot on the back end. So it might be a little bit more expensive up front, but working with an advisor, working with someone that can watch your back can make a big difference in the long run.
Absolutely. I primarily do litigation, and nothing makes me happier than getting a case where I look at the contract and it's well written and the intent of the parties is clearly and expressly stated in an unambiguous manner, and the dispute resolution provision is exactly what the client thought it was, and the location and jurisdiction where the client thought it was, and there's an attorney's fees provision that the client wanted to include and was able to include, to where if the client wins, they can also seek their prevailing party attorney's fees. And it just makes the litigation so much easier because the wrongdoing generally is accounted for in the contract, and we're not trying to say, well, what they really meant was X and what they should have said was Y.
Mm-hmm.
And all that is done on the front end of the business relationship. And so we obviously can litigate contracts that don't exactly say what they should say, but it was always the intent of the parties to mean a certain thing. But it makes it so much easier if the contracts are well written and if lawyers were involved on the front end. And in reality, it also increases litigants' chance of success if they have a contract in their favor.
Yeah, of course. And likely overall cost, if they have someone work on it, do it right the first time, then on the back end, it'd be that much cheaper. And so
Absolutely.
Those contracts that you're seeing that make you happy, I'm sure those are ones that you were directly involved in. So nice job. All right. So that's a lot of helpful information, David. Where can people find you if they're looking to get more information about you, SFL, or any of the topics that we talked about today?
Great. So we can be reached on the web, www.sfl-law.com. On our website, we have all of our attorneys, our practice areas, our locations, representative examples of our work in the past, and a really good overview of our firm. And beyond that, we're available by social media, by phone, by email, you name it, and we're available and accessible that way.
Awesome. What social media platforms do you prefer where people can reach out?
So we use LinkedIn a lot. We also have Instagram and Facebook, and we're old-fashioned, so we utilize telephone and email predominantly with interacting with our clients.
Awesome. So you're really present online. People can find you at sfl-law.com and on LinkedIn. So
yes.
If anyone has any questions, like what they hear, like to talk to David, more, be sure to reach out. Awesome, David. Well, thanks so much for the time today. A lot of helpful information, and we'll be sure to talk to you soon.
Absolutely.
All right. Thanks.